makers of the silencers are the ones pushing state lawmakers to lift the ban, and they have found at least one supporter.
Law enforcement later surmised he was shot by someone using a silencer.
Whiteside County Sheriff, to discuss about the new bill, and he says that the bill is unconstitutional.
There have been numerous instances, whether intentional or unintentional, of Biden administration officials and anti-gun advocates and even the president.
Again, as ATF director, what Congress passes is what we deal with.
And I was sharing with you my knowledge of a program in which ATF has defined this term.
In effect, banning, or at a minimum, severely restricting.
This law's broad immunity means blanket immunity, and that gun manufacturers are the only industry in America.
Second Amendment protects firearms in common use at the time and also said this, quote, for lawful purposes like self-defense.
But, Madam Speaker, guns have been prevalent in the United States of America since before our founding.
Getting assault weapons, AR-15s, out of the hands of people who shouldn't have them.
Most significant federal gun restrictions in decades on Friday following years of false starts and failures to tighten gun laws.
Were impacted by the gunfire that was happening around them and the subsequent stabbing and destruction of evidence.
A new suppressor statute was passed, signed into law, and is being used in conjunction with the ongoing efforts to overturn the NFA and ATS regulations of suppressors, as well as the Texas Suppressor Freedom lawsuit. Bill to remove suppressors from NFA. The American Suppressor Association is pleased to announce the reintroduction of the Hearing Protection Act by Rep. Jeff Duncan and Rep. John Carter. This historic piece of legislation, which was originally introduced by Rep. Matt Salmon in the 114th Congress, will remove suppressors from the purview of the National Firearms Act, replacing the antiquated federal transfer process with an instantaneous NICS background check. The HPA also includes a provision to refund the $200 transfer tax to applicants who purchase a suppressor after October 22, 2015, which was the original date of introduction. The American Suppressor Association believes that citizens should not have to pay a tax to protect their hearing while exercising their Second Amendment rights, said Knox Williams, President and Executive Director of the ASA. We are thrilled for the opportunity to work with Representatives Duncan and Carter, who have reintroduced the Hearing Protection Act in this new Congress. Although we recognize that introducing this bill is the first step in what will be a lengthy process to change federal law, we look forward to working on the Duncan-Carter bill alongside the Congressional Sportsman Foundation and the NRA to advance and ultimately enact this common-sense legislation. Also known as silencers, suppressors are the hearing protection of the 21st century sportsman. Despite common Hollywood-based misconceptions, the laws of physics dictate that no suppressor will ever be able to render gunfire silent. Suppressors are simply mufflers for arms, which function by trapping the expanding gases at the muzzle, allowing them to slowly cool in a controlled environment. On average, suppressors reduce the noise of a gunshot by 20 to 35 decibels, roughly the same sound reduction as earplugs or earmuffs. In addition to hearing protection, suppressors also mitigate noise complaints from those who live near shooting ranges and hunting lands. Unfortunately, suppressors have been federally regulated since the passage of the National Firearms Act of 1934. The NFA regulates the transfer and possession of certain types of arms and devices, including suppressors. Currently, prospective buyers must send in a Form 4 application to the ATF, pay a $200 transfer tax per suppressor, undergo the same background check process that is required to purchase a MASH arm, and wait months for the ATF to process and approve the paperwork. In stark contrast, many countries in Europe place no regulations on their purchase, possession, or use. The Duncan-Carter Hearing Protection Act will fix the flawed federal treatment of suppressors, making it easier for hunters and sportsmen to protect their hearing in the 42 states where private suppressor ownership is currently legal, and the 40 states where hunting with a suppressor is legal. This legislation will remove suppressors from the onerous requirements of the NFA, and instead require purchasers to pass an instant NICS check, the same background check that is used during the sale of long arms. In doing so, law-abiding citizens will remain free to purchase suppressors, while prohibited persons will continue to be barred from purchasing or possessing these accessories. Trump-era bump stock ban overturned by federal appeals court. A Trump administration prohibition on bump stocks, which enable a shooter to rapidly fire multiple rounds from a semi-auto weapon after pushing the trigger once, was overturned by a federal appeals court in New Orleans. The ban was implemented in response to the mass slaying of several dozen people in Las Vegas in 2017 by a killer utilizing arms equipped with bump stocks. Arm rights activists have challenged it in a number of courts. The Fifth U.S. Circuit Court of Appeals rendered the most recent ruling on the issue, which will likely be decided by the Supreme Court 13-3. The verdict won't instantly lift the prohibition, even though it will now go back to the lower court to decide how to proceed. Because the issue in this case was not the Second Amendment, but rather the proper interpretation of federal legislation, it was a little different from other cases. Bump stocks are not illegal mash weapons under federal law, as stated by those who oppose the ban. The U.S. Bureau of Alcohol, Tobacco, Firearms, and Explosives claims that they do. The Biden administration is presently defending this assertion. The lead majority opinion was written by Judge Jennifer Walker Elrod, who stated that a bump stock is not included in the technical definition of a mash gun, as defined by the Arm Control Act and the National Firearms Act. This conclusion is reached after closely examining the mechanics of a semi-auto arm and plainly reading the statutory language.
And to use it lawfully. That's not a right of government.
There have been numerous instances, whether intentional or unintentional, of Biden administration officials and anti-gun advocates and even the president.
They just want to regulate guns. They don't. They want to abolish guns.
That this law's broad immunity means blanket immunity, and that gun manufacturers are the only industry in America.
The court decided that bump stocks are not covered by the definition of a mash arm, which is specified in two separate federal statutes. The 6th U.S. Circuit Court of Appeals in Cincinnati, the 10th Circuit in Denver, and the Federal Circuit Court in Washington had all challenged the ban before it was overturned. 3 justices on the 5th Circuit panel affirmed a lower court ruling supporting the ban, made by a federal judge in Texas. Still, the entire court in New Orleans made the decision to reconsider the matter. On September 13, disagreements were heard. Bump stocks are designed to capture the energy of recoil from semi-auto arms. This allows the arm to reset and fire without the shooter having to physically manipulate the trigger again, as stated by the ATF. Court documents state that a shooter must keep the non-shooting hand on the weapon and provide persistent forward pressure, as well as continuous trigger finger pressure. The ATF ruling was opposed by the entire appeals court. They had argued that the weapon does not fit the statutory definition of a mash arm since a bump stock repeatedly pulls the trigger. They point to a paragraph in the law that defines a mash arm as one that discharges continuously with a single function of the trigger. A resounding majority also agreed that Congress should settle legal ambiguities in conformity with the legal ideal of lenity. In a dissenting opinion, Judge Stephen Higginson refuted the assertion that bump stocks are not machine weapons as defined by federal law. He further asserted that the majority had used the lenity concept too liberally. According to Higginson, under the majority's rule, the defendant wins by default in situations where the government is unable to show that a legislation clearly criminalizes the defendant's behavior. Testifying against the restriction on behalf of an arm owner in Texas, Richard Samp voiced his satisfaction with the ruling at the September proceedings, saying he had expected it. Samp claimed to have testified against the law on behalf of an arm owner in Texas. Requests for comments made during the evening were not answered by the Justice Department. The judges who decided against upholding the restriction included Elrod, Priscilla Richmond, Edith Jones, Jerry Smith, Carl Stewart, Leslie Southwick, Katharina Haynes, Don Willett, James Ho, Kyle Duncan, Kurt Engelhardt, and Corey Wilson. Except for Stewart, every member of the appeals court was appointed by the Republican Party. Judge Higginson's dissenting opinion was concurred with by Judges James Dennis and James Graves. Judge Dana Douglas, a recent appointee of Democratic President Joe Biden to the Fifth Circuit Court of Appeals, presided over the argument. Fifth Circuit overturns ATF's bump stock law. In the Cargill v. Garland case, the Fifth Circuit Court of Appeals upheld the legitimacy of the ATF's final rule on bump stocks, overturning the ATF's abuse of power. The ATF recommended that the Supreme Court review the Cargill case in order to support their bump stock regulation. The Fifth Circuit reversed the lower court's decision and sent it back to the district court for a decision that would have favored the plaintiffs. This ruling had a big influence on the new regulation, previous ATF overreach regulations, and bump stock legislation. Whether the ATF's final rule on bump stocks should be deferred to Chevron, or if an independent rule called the Lindy Rule should be applied instead, was one of the key questions in this argument. The Fifth Circuit's Amang panel determined 13-3 that the ATF had overreached itself in designating bump stocks as mash guns in accordance with the General Motors Act. According to them, the ATF regulation violated the legal tolerance for individual liberty. The technical definition of a mash gun as defined by the GCA and NFA does not contain a bump stock, as can be shown by a cursory study of the relevant statute text and some basic understanding of the workings of a semi-auto weapon. The agency's standard interpretation, according to the court, that the ban on mash guns does not extend to the particular type of bump stock in question, is untrue.
In effect, banning, or at a minimum, severely restricting
The limited exemptions are negligence, knowingly selling to somebody who's not allowed to have a firearm.
In the event that Congress or the ATF wishes to expand the definition of a mash gun to include items such as bump stocks, they must amend the Act's language. The ATF is powerless to do so on their own. The ATF filed a petition with the Supreme Court to review the Fifth Circuit's decision because they believed it to be at odds with decisions rendered by other circuit courts. The identical interpretive rule has already been challenged and rejected by these other circuits. The ATF goes on to say that after submitting their petitions, circumstances have changed, which has further complicated the legal system. The Hardin decision, a recent ruling by the Sixth Circuit Court of Appeals, has stoked controversy regarding bump stock regulations. Given that some circuit courts allow the purchase or possession of bump stocks and others do not, this ruling highlights the importance of the Supreme Court re-examining the matter. This disparity compromises the consistency of federal law, since decisions made by other courts that have rejected similar arguments have less practical significance. The majority of bump stocks manufactured and sold in the Sixth Circuit, according to the ATF, will likely soon be located in other regions of the country, which makes a unified legal framework even more necessary. The ATF believes that bump stocks pose a substantial risk to law enforcement and the public, even in the absence of compelling evidence. It is even more critical to remedy regulatory discrepancies in light of the perceived threat. In an effort to have the matter heard and granted certiorari, both sides have implored the Supreme Court to reconsider the case. The Sixth Circuit Court of Appeals concluded that the wording used in the Act was ambiguous and chose to follow a standard more akin to the rule of Lindy than the Chevron deference approach. Currently, both parties are requesting a review from the Supreme Court, but they are approaching the matter in different ways. The ATF is opposing any attempt to specifically include the rule of Lindy in the question for this case, arguing that the question they initially submitted to the Supreme Court in their petition will adequately address the issue. The fact that both parties are asking for reconsideration, albeit in different ways, is noteworthy.
That is not a priority.
Okay, here's the problem we have. Here's the problem we have. Okay, you ran for Ohio Attorney General in 2018.
And in those cases, firearms dealers on the southwest border are required to make a multiple sale report.
I believe, to infringe upon good law-abiding Americans' rights, and you're going to turn them into criminals with this regulation, and you seem to have no remorse about it.
Where they were labeling their weapons. Would there be a label on the wall for assault weapon?
The ATF has previously stated that it is against the idea of bringing up the rule of Lindy in particular, outlining its strategy for the impending legal dispute. The reason the Supreme Court is particularly interested in this subject is that it is often called upon by circuit courts to resolve conflicts of law by providing the court with guidance on important legal matters. The Fifth Circuit en banc panel's decision rejecting the bump stock ban would set precedent in the Fifth Circuit and prevent the ATF from enforcing the limitation there if the Supreme Court decides to grant review. The Supreme Court might find it challenging to decline to consider this case, considering the range of opinions and decisions from other circuits. The potential for notable differences in federal law and ATF enforcement underscores the gravity of this issue, indicating that the Supreme Court will probably have to take it up. Suppressor freedom law. The NFA and ATF prohibitions on suppressors manufactured in Texas were to be repealed through the Texas suppressor freedom litigation. Paxton versus Dettelbox, as the case was once known, was decided on cross motions for summary judgment. The judge's decision seems like a softball because standing is invoked as an excuse to sidestep discussing contentious matters. The plaintiff's lack of a tangible injury to satisfy the standing requirement was decided by the court. Furthermore, the court ruled that Texas could not act as a stand-in for its citizens to sue the government over the NFA's application to suppressors manufactured in Texas. Texas House Bill 957, which sought to exempt all suppressors manufactured and stored in the state from federal regulation, gave rise to the case. This statute was based on the argument that since these products are only manufactured and marketed in Texas, they do not qualify as interstate commerce and are therefore exempt from federal regulation by the ATF. Texas filed the complaint against the government together with individual plaintiffs, and as a result, this matter was brought before a federal court on cross motions for summary judgment. The court was faced with three options after arguments last month. It could allow the plaintiffs' move for summary judgment, rule in favor of Texas and the individual plaintiffs, or grant the government's request for summary judgment in favor of the ATF. Ultimately, the court decided that the government had the right to win the case, finding that the plaintiffs lacked legal standing. Additionally, they might be able to boost their reputation by proving that they have been directly threatened by the ATF about the manufacture of homemade suppressors. A party must establish a reasonable danger that they will sustain a direct injury as a result of the legislation's execution in order to successfully challenge a criminal statute before it is put into effect.
Gun enthusiasts hope lawmakers will pull the trigger and lift the ban on silencers.
As suppressors, illegal nationwide, just as they are in New Jersey.
But according to the judge, a plaintiff would have to engage in actions deemed unlawful before they could legally challenge the ATF. This would be akin to the plaintiff falling on their own sword for the benefit of the Second Amendment movement as a whole. In this instance, the judge decided that just claiming that the statute in question infringes upon the rights in question and violates the Second Amendment does not relieve the burden of showing standing. It doesn't matter if an application is eventually approved or denied, because the individual plaintiffs haven't attempted to file an application to produce and register a silencer. It is possible for the plaintiff to suffer harm as a result in any scenario. In the event that an application is unintentionally rejected, the government will have injured the applicant by depriving them of a silencer. On the other hand, since the plaintiff will have to go through the procedure and pay the tax, even if the application is approved, they can still sustain losses. According to the judge, the plaintiff's wish to show that they were in violation of these laws by producing a silencer does not establish that the method they are trying to challenge has caused them any real injury. To put it simply, people must subject themselves to the exact process that they want to scrutinize. The question of Texas's legal standing to file this complaint is also addressed by the court. In an attempt to prevent the National Firearms Act from applying to suppressors built in Texas, the judge determined that the state of Texas could not file a lawsuit against the federal government on behalf of its residents. Suppressor Freedom Lawsuit. Alright, so picture this. There's this ongoing legal showdown that's stirring up some serious buzz in the firearms community. We're talking about the Suppressor Freedom Lawsuit, a real game changer in the fight against suppressor bans in certain states. Now let's dive into what's really cooking here. So, why all the fuss? Well, it's about challenging bans on suppressors, those nifty little devices designed to reduce the noise of gunfire.
The Second Amendment, from the day it was passed, limited the type of people who could own a gun and what type of weapon you could own.
Directly attack the issue at hand, and for me, it's very laser focused. It's violent crime in the metro.
Turns out, some states aren't big fans of these gadgets and have slapped bans on their purchase and possession. That's where this lawsuit struts onto the scene, guns blazing. Figuratively speaking, of course. Now, zooming in on the action, there are two heavyweight lawsuits causing a stir, both swinging punches at suppressor bans in Illinois. First up, we've got the Morris versus Raoul case, and then there's Anderson versus Rule case. These bad boys were filed in a federal district court in Illinois, and let me tell you, they're causing ripples in the legal waters. These lawsuits aren't just about fighting for the right to own suppressors. They're about challenging the bans that put a clamp on lawful ownership. See, in a bunch of states, including Illinois, there's this ban preventing folks from getting their hands on suppressors, despite them being legal and widely used in 42 other states. These cases are pretty darn important, because they're taking a swing at bans that don't quite match up with the Second Amendment. You know, that whole right to bear arms thing? Yeah, that one. It's arguing that these bans are stepping on that constitutional right. And hey, these aren't your run-of-the-mill legal tussles. No, sir. these cases are the first of their kind, aiming to shake things up by saying, hey, this ban on suppressors? Not cool, not constitutional.
Our Second Amendment. It's a hell no to government trampling on our freedoms.
I think you need to have weapons to take on the government. You need F-15s and maybe some nuclear weapons.
Change a law. They are already used to breaking the law, and the people will still do it, will continue to do it.
People are rallying around these lawsuits because they're challenging the status quo. They're saying, hey, 42 states think suppressors are all right, so why not here? It's all about standing up for what's believed to be a fundamental right, a right that's being denied in a handful of places, including Illinois. So picture this legal battleground as a way to fight for the freedom to own and use these suppressors without the heavy-handed bans. It's like the Wild West of legal disputes, and these lawsuits are aiming to carve a path toward freedom for folks who want to exercise their Second Amendment rights without unnecessary restrictions. Challenging suppressors ban. Buckle up, because we're about to dive deep into the legal battlefield that's brewing in Illinois. Two lawsuits, Morris versus Raoul and Anderson versus Rule, are causing quite the stir in a federal district court. And let me tell you, they're not your average legal scuffles. Nope, these lawsuits are packing some serious heat as they take aim at challenging suppressor bans in the land of Lincoln. In 42 states across this fine nation, owning a suppressor is A-OK.
Guns don't kill people, people kill people. Criminals, miscreants will always get their hands on guns.
Were impacted by the gunfire that was happening around them and the subsequent stabbing and destruction of evidence.
But then there are these select places, including Illinois, where bans on these noise-reducing gadgets are throwing a wrench in the works. And that's where these lawsuits step in. They're not just about fighting for the right to own suppressors. They're about challenging these bans that are blocking lawful ownership. Morris versus Raoul and Anderson versus Rule are making waves because they're taking on these bans head-on. They're strutting into the legal arena, guns metaphorically blazing, to argue that these bans are infringing upon Second Amendment rights. You know that old chestnut about the right to bear arms? Yeah, that's what's on the line here. The significance of these lawsuits can't be overstated. They're not just about suppressors, they're about setting a precedent. If successful, they could pave the way for similar challenges in other states with bans on these handy devices. They're aiming to say, hey, just because we're in Illinois doesn't mean we shouldn't have the same rights as folks in other states. And boy, are these lawsuits making some strong points. They're arguing that these bans are unconstitutional, that they're putting unnecessary shackles on law-abiding citizens who just want to exercise their rights without jumping through hoops. What's fascinating here is that these lawsuits aren't just about the present, they're about shaping the future. They're saying, hey, let's rethink these bans and ensure that our rights are protected for generations to come.
We have the third highest gun-related injuries in the country, 90% higher.
Gun violence in this country is an epidemic, and it's an international embarrassment.
Now, the nitty-gritty of these cases is where things get real interesting. They're challenging the very foundation of these bans, arguing that they're not in line with the Second Amendment. They're saying, look, suppressors are commonly used tools, not some wild, dangerous contraptions, so why are they being banned? The hope here is that these lawsuits will serve as a wake-up call. They're not just legal battles, they're fights for fairness and rights. They're aiming to shine a light on these bans that, let's face it, seem a tad outdated in a world where the majority of states have no issue with suppressor ownership. In a nutshell, Morris versus Raoul and Anderson versus Rule are leading the charge against suppressor bans in Illinois. They're like beacons of hope for those who believe in the fundamental right to own and use suppressors without unnecessary restrictions. And who knows, their success might just trigger a domino effect, inspiring similar challenges in other states with similar bans. The argument. Illinois is stirring the pot, arguing that suppressors shouldn't get the same Second Amendment love as firearms. They're playing hardball, claiming that these noise-reducing gadgets don't quite make the cut as arms. According to them, suppressors are more like accessories, not the real deal. Their whole shebang revolves around this idea that because suppressors don't shoot bullets themselves, they're not covered under the Second Amendment's protective umbrella. They're making this distinction between what's considered a full-on arm and what's just a fancy attachment for firearms. It's like saying, sure, you've got your gun, but that silencer? Nope, not protected.
But at the crux of this is a bureaucrat making a unilateral decision to try to turn millions of Americans into felons.
Most significant federal gun restrictions in decades on Friday following years of false starts and failures to tighten gun laws.
Their playbook includes this argument that suppressors are not the kind of tools the Founding Fathers had in mind when they penned the Second Amendment. They're making this case that the amendment is all about guns, actual firearms, and suppressors, well, they're just extras, like a cool accessory you add to your favorite firearm. It's like they're trying to throw suppressors under the bus, saying they're not in the same league as guns when it comes to constitutional protection. According to Illinois, the Second Amendment is all about guns and not about these noise-muffling attachment thingamajigs. Now, this argument might sound all fine and dandy until you consider a few things. First off, federal laws actually treat suppressors as firearms. Yeah, you heard that right. Uncle Sam says, hey, these little gizmos, they're the real deal. But Illinois is out here saying, nah, let's ignore that. They're just doodads, not actual arms. Plus, let's not forget the bigger picture here. The Second Amendment talks about arms, not just guns. It's a broad term, kind of like an umbrella covering all sorts of things that go bang, or could be used for protection. Illinois is trying to narrow it down, saying, nope, just guns, please. But here's the kicker. These lawsuits are pushing back against that narrow view. They're saying, hey, the Second Amendment's not just about muskets or the stuff they had back in the day. It's about the right to bear arms, whether they're old school or the latest tech.
This rule turns law-abiding gun owners into felons is a result of unelected bureaucrats
Getting assault weapons, AR-15s, out of the hands of people who shouldn't have them.
So while Illinois is trying to disqualify suppressors from that constitutional protection, these lawsuits are fighting tooth and nail to widen the scope, arguing that modern tools like suppressors should also fall under the Second Amendment's protective umbrella. It's a classic clash of interpretations, and boy is it heating up the legal battleground. Judgment on the pleadings. In the legal bout surrounding suppressors, Illinois is pulling out all the stops with a move straight out of the legal playbook, a motion for judgment on the pleadings. It's like trying to end the game before the first whistle blows. This maneuver is their ace in the hole, their shot at saying, case closed, nothing to see here, before things even kick off in court. Their whole aim? To dismiss the whole shebang before it even reaches trial.
But, Madam Speaker, guns have been prevalent in the United States of America since before our founding.
If you were serious, you would acknowledge that 96% of mass public shootings happen in an area where guns are banned.
All based on the premise that suppressors simply don't qualify as arms protected under the Second Amendment. It's like they're arguing, hey judge, we're all for gun rights and all that jazz, but these suppressors? Nah, they're just fancy add-ons, not the real deal. So how are they making this case? Well, they're taking a hardline stance, trying to convince the judge that suppressors don't fit the criteria to be considered arms under that hallowed Second Amendment. According to Illinois, for something to be covered by the constitutional love, it's got to be the main event, the star of the show. And in their playbook, suppressors are just the sidekicks, the extras that don't deserve that same level of protection. Their argument hinges on this idea that when the Founding Fathers were penning the Second Amendment, they weren't picturing suppressors. Nope, not at all. They're saying it's all about guns, actual firearms, nothing more, nothing less. It's like they're telling the judge, you've got to shoot bullets to get into the Second Amendment club. But hold your horses, Illinois. The folks on the other side of this legal showdown aren't backing down that easily. They're playing their own tune, arguing that the Second Amendment isn't just about the muskets and rifles of yesteryear. Oh no, it's bigger than that. It covers all kinds of arms, including modern tools like suppressors. So while Illinois is trying to slam the door shut on this case, the other side is like, not so fast. They're arguing that suppressors absolutely fit the bill of what the Second Amendment protects. They're saying, hey, times change and so do the tools. The right to bear arms? It includes these noise-muffling gizmos too.
Our Second Amendment. It's a hell no to government trampling on our freedoms.
Second Amendment protects firearms in common use at the time and also said this, quote, for lawful purposes like self-defense.
It's a classic clash of legal interpretations, a showdown between narrow and broad views of the Second Amendment. Illinois is taking a swing at ending this tango early, while the other side is gearing up for a fight, refusing to let this debate slide into a quick dismissal. So, there you have it. a legal tug-of-war over what falls under the protective wings of the Second Amendment. It's like a battle of wits, each side trying to outmaneuver the other in the courtroom. And in the end, the judge will be the one holding the gavel, deciding whether this legal show gets a curtain call or goes on to the full production. Definition dispute. The good old debate about suppressors. Are they the real deal? Arms protected by the Second Amendment? Or just fancy add-ons to firearms? This is the heart of the clash in the legal arena, where one side is saying, hey, they're arms, while the other argues, nope, they're just accessories. So let's break it down. On one side of the ring, you've got Illinois and its crew arguing that suppressors don't make the cut to be considered arms under the Second Amendment. They're painting these noise-dampening devices as mere extras, like the cherry on top of your sundae, not the sundae itself. According to them, the amendment only covers actual firearms, not these fancy add-ons. But here's where things get interesting. Federal laws have a different story to tell. Uncle Sam's legal books actually treat suppressors as firearms themselves. So while one side is trying to downplay suppressors as just accessories, the other side is waving the federal rulebook saying, nope, they've got a place at the firearms table. It's a classic clash of interpretations, a legal puzzle with real-world implications, all centered around this question of what suppressors truly are, mere add-ons or bona fide firearms in their own right. Impact of recent California decisions. The legal landscape is ablaze with recent events in California, where court rulings in Miller v. Bonta and Duncan v. Bonta threw a colossal wrench into certain firearm restrictions, deeming them unconstitutional. This seismic shift in California's legal terrain isn't just local gossip. It's sending shockwaves across state borders, particularly resonating in the Illinois suppressor case. In those California courtrooms, judges dropped the mic, declaring certain restrictions on firearms unconstitutional. It's like they lit a beacon, signaling a new era in the legal battle for firearm rights. But what's even more fascinating is how these California rulings are playing a role thousands of miles away in Illinois, specifically in the fight against suppressor bans. The legal maestros behind the Illinois suppressor case are pointing fingers at these California decisions, saying, hey, this is precedent, and it's got something to say about our case too. They're wielding these rulings like a mighty sword, arguing that if California restrictions got the boot for being unconstitutional, maybe, just maybe, similar bans on suppressors in Illinois should meet the same fate. Imagine it as a legal domino effect.
Gun enthusiasts hope lawmakers will pull the trigger and lift the ban on silencers.
On our vehicles is because they're incredibly loud. That output is incredibly loud. The muffler helps dampen that noise. The suppressor is the same way.
The impact of these California decisions isn't confined within state lines. It's like they become a guiding light, casting a legal shadow that stretches far beyond the West Coast. The arguments made and the strategies employed in California are now finding their way into the courtroom discussions in Illinois. These rulings have become more than just legal victories. They're now critical support for other battles, including the fight against suppressor bans. They're serving as a blueprint saying, look, if these firearm restrictions in California were deemed unconstitutional, maybe the bans on suppressors in Illinois should face a similar fate. And the folks behind the Illinois suppressor case aren't shy about leveraging these California decisions. They're citing them as persuasive evidence, using them as a beacon of hope for their fight against suppressor bans. It's like they're saying, see, if these restrictions on firearms got axed in California, then perhaps these suppressor bans here in Illinois should face the same scrutiny. This isn't just a legal tussle, it's a narrative of how one state's court rulings are shaping the battle for rights across the nation. Those California cases have gone from local headlines to becoming integral chapters in the broader story of constitutional rights and firearm regulations. So as the drama unfolds in Illinois over suppressor bans, those California rulings are playing a supporting role, standing as a precedent that might just tilt the scales in favor of those fighting for their right to own and use suppressors without unnecessary restrictions. They become more than legal victories. They become symbols of hope and influence in a fight for broader rights across different states. Importance of 2A wins. The significance of victories in firearm-related cases across different jurisdictions stretches far beyond state borders. It's like a ripple effect that reverberates through the entire legal landscape. These wins aren't just isolated triumphs, they're dominoes that can potentially shape the outcome of battles for firearm rights in various corners of the nation. When a jurisdiction scores a win in a Second Amendment case, let's say a successful challenge against certain firearm restrictions, it's not merely a local celebration. It's a beacon of hope for those fighting similar battles in other states. These wins carry weight, setting precedents and creating a roadmap for other legal warriors in the broader fight for constitutional rights. Consider this: a courtroom victory in California over firearm restrictions isn't just about California. It's like a spark that ignites fires in other states, providing a foundation for arguments and strategies in cases miles away. These wins become a reference point, a guiding light that says, hey, if it worked here, maybe it could work there too. Let's take the recent triumphs in California's Miller versus Bonta and Duncan versus Bonta as an example. Those victories weren't confined to the Golden State. They've become part of a larger narrative in the battle for firearm rights. The arguments and rulings in those cases are being used as supportive precedents in fights against suppressor bans in Illinois and potentially influencing similar cases in other states.
The suppressor will reduce the muzzle flash so that they couldn't ignite those gases.
Word that Sheriff Hart is also against the new bill that was passed on Tuesday.
Wins in different jurisdictions aren't just about celebrating victories, they're about building momentum. They create a network of legal support where successful arguments and rulings in one area become ammunition for battles in others. It's like a domino effect. Each win nudges the next, influencing legal landscapes and strengthening the fight for constitutional rights on a broader scale. These victories serve as vital building blocks in the larger mosaic of firearm-related rights across the country. They're not standalone triumphs, but interconnected pieces that contribute to a tapestry of legal precedents, shaping the understanding and interpretation of constitutional rights in different jurisdictions. So when you hear about wins in 2A cases across various states, remember, they're not just individual victories, they're building blocks in a larger movement. They pave the way for challenges against restrictive laws in other areas, offering hope and support to those fighting for their rights, creating a legal landscape where each success breeds potential for broader change. Supplemental authorities. In the high-stakes legal tango of the Illinois suppressor case, the judge made a game-changing move that has tongues wagging and hearts racing. Imagine the scene. The courtroom buzzes with anticipation, and then, in a pivotal moment, the judge gives a subtle nod, signaling the acceptance of two heavyweights into the legal arena, Miller versus Bonta and Duncan versus Bonta, the supplemental authorities. These decisions aren't just pieces of paper, they're power players in the legal sphere. Their inclusion signals their significance, their potential to influence the outcome of the Illinois suppressor lawsuit. It's like shining a spotlight on recent victories against certain restrictions, suggesting that they might set a precedent for similar cases elsewhere. Their acceptance into the Illinois case isn't just a casual nod, it's a recognition of their potential impact.
Fitted with a suppressor to kill 12 Americans in Virginia Beach.
State lawmakers are considering several changes to gun laws, including making these much easier to get.
These rulings are being cited as persuasive evidence, saying, hey judge, look at what happened in California. Those decisions against certain restrictions, they could guide our way here in Illinois too. Their presence in the courtroom isn't just for show, it's a beacon of hope for those fighting against suppressor bans in Illinois, suggesting that recent victories elsewhere might just tilt the scales in their favor. It's like planting a seed of possibility, hinting that these decisions could influence the judge's perspective and shape the outcome of the Illinois legal battle. The judge's acceptance of these supplemental authorities isn't just a routine legal step, it's a significant development that underscores their potential impact. So, as the Illinois case unfolds, the inclusion of these California decisions isn't just a footnote, it's a narrative thread that could weave its way into the final judgment. Their acceptance signifies a willingness to consider how recent victories against firearm restrictions might hold relevance and influence the course of the Illinois suppressor lawsuit, offering a glimmer of hope to those advocating for broader firearm rights. Potential ripple effects. Picture this: the Illinois suppressor case reaches its crescendo, and the judge's gavel falls in favor of overturning suppressor bans. What happens next? Well, that's when the legal earthquake starts sending seismic waves across the nation, potentially reshaping the landscape of firearm rights. A favorable outcome in the Illinois case against suppressor bans could trigger a series of domino effects with far-reaching consequences. First off, it's not just a win for the folks in Illinois, it's a victory that could echo far beyond state lines. This decision could become a guiding light, a legal precedent that says, hey, if it worked in Illinois, it could work elsewhere too. Imagine it as a legal blueprint. Lawyers and advocates in other states facing similar suppressor bans.
The state house still has to vote on the bill. 9 on your side's Craig Smith looked into how much difference a suppressor makes.
How much louder is it without the silencer?
It's about 6 times louder without the silencer.
Might point to the Illinois decision, saying, look, this ruling sets a precedent. It challenges the notion that suppressors aren't protected under the Second Amendment. It's like using a torch to light up a path, showing that bans on suppressors might not stand the test of constitutional scrutiny. And it's not just about suppressors either. The ripple effects of this decision could extend to challenges against other restrictive firearm laws. It could bolster the broader fight for Second Amendment rights, creating a legal landscape where victories in one jurisdiction become ammunition for battles in others. This decision could become a tool in the arsenal of those fighting against unnecessary restrictions on firearm accessories. It's like opening a door to a new legal avenue, suggesting that the right to own and use suppressors might be more firmly protected than previously thought. But remember, this is all speculation until that judge bangs the gavel and makes the call. A favorable outcome in the Illinois suppressor case isn't a guarantee that bans in other states will fall like dominoes. However, it's a catalyst, a potential game changer that could set off a series of legal challenges and pave the way for broader recognition of suppressor rights across the country. Let's take the recent triumphs in California's Miller versus Bonta and Duncan versus Bonta as an example. Those victories weren't confined to the Golden State. They've become part of a larger narrative in the battle for firearm rights. The arguments and rulings in those cases are being used as supportive precedents in fights against suppressor bans in Illinois and potentially influencing similar cases in other states. As the Illinois case unfolds, the inclusion of these California decisions isn't just a footnote, it's a narrative thread that could weave its way into the final judgment. Their acceptance signifies a willingness to consider how recent victories against firearm restrictions might hold relevance and influence the course of the Illinois suppressor lawsuit, offering a glimmer of hope to those advocating for broader firearm rights. State-by-state suppressor deregulation. A Mississippi statute, largely influenced by the Texas suppressor freedom lawsuit and ongoing efforts in Texas's Fifth Circuit to repeal Maiden's NFA and ATS regulations, has been enacted. This law, known as HB 912, collaborates with the Texas suppressor freedom lawsuit, aiming to create a state-by-state movement to deregulate suppressors exclusively manufactured and kept within certain states. The Mississippi governor signed and sent HB 912 earlier this year, and its existence came to attention when some viewers mentioned it in the Texas suppressor freedom case. The Mississippi law seeks to ensure that arms suppressors produced and retained in the state are exempt from federal laws and regulations governing such devices. Additionally, it prohibits state and local government representatives from enforcing federal regulations on suppressors made in Mississippi. The primary objective of the Mississippi law mirrors what Texas achieved with its suppressor freedom law.
Makers of the silencers are the ones pushing state lawmakers to lift the ban, and they have found at least one supporter.
The two, action people shooting at each other with suppressor, nobody else knows what's going on. That's completely unrealistic.
However, its implementation is contingent on the outcome of the ongoing Texas suppressor freedom lawsuit, specifically Paxton versus D. The law includes a provision withholding state funding from any government agency in Mississippi that adopts a rule or policy aiding in the enforcement of federal suppressor laws. While the Mississippi law has been passed and signed, it specifies that it will not take effect until the resolution of the Texas lawsuit mentioned within the legislation. This Texas lawsuit originates from House Bill 957, passed in 2021, aiming to exempt from federal regulation all suppressors made and retained in Texas. The argument revolves around Texas and a few individual litigants suing the ATF after facing oppression from others in the state. The case reached the Northern District of Texas Federal District Court, where a judge, upon cross motions for summary judgment, ruled in favor of the government and the ATF. The district court judge emphasized the contested element of standing, stating that the plaintiffs had not suffered an injury in fact, leading to the conclusion that they lacked standing. Consequently, the court ruled in favor of the government based on this rationale. Legal standing and challenges. The judge in the Texas case asserted that individual plaintiffs were correct in noting the government's history of prosecuting illegal possession of unregistered silencers. However, the judge emphasized that these plaintiffs failed to provide evidence that they possessed any illegal silencers or engaged in prohibited conduct. Furthermore, the plaintiffs did not demonstrate that they faced a credible threat of prosecution, and the judge stated that doctrines of criminal law prohibit convicting individuals based solely on thoughts, desires, or motives. Thus, the judge deemed the individual plaintiffs' fear of prosecution as imaginary or speculative, lacking the substantial basis required for Article 3 standing. In essence, the judge articulated that individual plaintiffs in Texas would need to allege possession of an illegal silencer or engagement in prohibited conduct that the ATF deems illegal to establish standing. The court also suggested that plaintiffs could demonstrate standing by showing direct threats from the ATF or by attempting to register one of these Texas-made suppressors with the ATF. The judge maintained that intent alone was insufficient. There must be evidence of actual illegal activity for standing to sue the ATF. In the Texas case relied upon by Mississippi, the lower court judge ruled that the state of Texas lacked standing to sue the ATF, arguing that the state could not represent its citizens in such a lawsuit.
Law enforcement later surmised he was shot by someone using a silencer.
Whiteside County Sheriff, to discuss about the new bill, and he says that the bill is unconstitutional.
Consequently, the judge granted the government's motion for summary judgment, dismissing the case in its entirety. Subsequently, Texas has appealed the ruling, requesting the Fifth Circuit Court of Appeals to examine and overturn the lower court's decision regarding standing. Texas argued that the case's constitutional significance warranted oral arguments, raising questions about whether Texans have the right to challenge statutory requirements before obtaining permission and paying the tax, and whether Texas can immediately defend its quasi-sovereign interests in the health and safety of its citizens. It's worth noting that some individuals have expressed indifference, stating that this Texas suppressor freedom case may not seem relevant to them. National implications of the Texas suppressor freedom case. Some individuals believe that the Texas suppressor freedom case exclusively pertains to Texas, but this is not accurate. The case is currently under review by the pro-Second Amendment First Circuit Court of Appeals. The decisions emanating from the First Circuit, including lower courts, have had widespread implications nationwide. It's crucial to recognize that more states than just Texas fall under the jurisdiction of the First Circuit. Additionally, states like Mississippi are proactively leveraging the Texas law and lawsuit, seeking to emulate similar deregulation for suppressors on a state-by-state basis. This case is expected to reach the Supreme Court eventually, or at the very least, request Supreme Court review. Any decision by the First Circuit or the Supreme Court will likely have broad applications for numerous Second Amendment cases and may prompt other states, potentially even your own, to pass laws similar to those in Texas and Mississippi, facilitating state-level deregulation of suppressors. In Mississippi, HB 912 stipulates that the law will take effect and be enforced after the U.S. Supreme Court rules in favor of the Texas Attorney General and the state of Texas regarding the passage and implementation of Texas House Bill 957. The specific case mentioned is Paxton v. D. This underscores the substantial ramifications of the Texas suppressor freedom case for potential state-by-state deregulation. It's essential to bear in mind that despite these developments, the ATF currently treats suppressors as regulated items subjected to the restrictions of the National Firearms Act and the Gun Control Act. The ATF will continue to pursue individuals who engage in this conduct without proper filing of a Form 1 and adherence to the correct procedures. For those in Mississippi, it's crucial to note that the state law, as outlined in HB 912, remains inactive until the resolution of the Paxton case. Texas has appealed the ruling, requesting the Fifth Circuit Court of Appeals to examine and overturn the lower court's decision regarding standing. Texas argued that the case's constitutional significance warranted oral arguments, raising questions about whether Texans have the right to challenge statutory requirements before obtaining permission and paying the tax, and whether Texas can immediately defend its quasi-sovereign interests in the health and safety of its citizens. Therefore, vigilance and compliance with existing regulations are still necessary. The hope is that the Fifth Circuit delivers another victory for Second Amendment advocates, possibly leading to Supreme Court review and further shaping the legal landscape for these cases. That's all for this video, folks. See you next time.